Now, I think it is fair to say that the bulk of opinion, if you will, is that a mandate to purchase insurance under current constitutional law, at least, is permissible. And so, sort of in light of that, I'm going to give David, who's going to argue against the constitutionality of the mandate, the first and the last words. So David is going to give the first opening statement, then Mike, and then at the end, Mike will close, and then at the end, we'll hear from David. So,
Ma'am, thank you very much for this introduction. Pleasure to be here. And let me dive right into it. I'll make a couple of points. One broad one. I don't think anybody would disagree, but the federal government is a government of limited and enumerated powers. I don't think anybody would disagree that this is something that was enormously important from a framer's perspective. And when people talk about separation of powers, they typically think in terms of a horizontal separation of powers among the three coordinate branches of the federal government. But if you actually look at the history of a founding debates in the Constitutional Convention, of state ratification debates, you would see that the framers paid at least as much attention, if not more attention, to the vertical separation of powers, the dual sovereignty system, which really was probably the only original, no pun intended, innovation of framers, because the horizontal separation of powers is certainly something that they borrowed from our authorities. Now, as far as the framers were concerned, these types of structural limitations in governmental power are actually more important than the provisions of the Bill of Rights, which most people think these days is the only business there is. Incidentally, this is not some archaic 18th century whimsy. This is something that's very much au courant with the modern sort of progressive jurisprudence. I was recently debating in Yale the merits of a Cayamba case, which the Supreme Court just unfortunately granted cert. And in preparing for it, I reread the Boumediene decision, and you cannot get away from sort of being impressed, I mean, if you disagree with it, as I do, of Justice Kennedy's pieance to the notion that no single branch of government should amass too much power, and that is the key provision, the key structural aspect of the Constitution. Now, why are we concerned? How does this broader principle apply here? Well, if you look at the individual mandate, and by the way, not to be funky about this, but as you may know, Congressional Research Service, which is an entity typically quite helpful to Congress, takes as expensive of a view of Article I powers as OLC, which I'm much more familiar, takes of Article II powers when they asked our chairman of the Senate Finance Committee to opine on this, use words like unprecedented and novel, which ain't exactly a green light. Back in my White House counsel days, if OLC told me that something is novel and is unprecedented, I would not construe it as a green light. Now, so what are we talking about here? It has to be a Commerce Clause or a tax and spend clause, which we'll hopefully talk a little bit later. On the Commerce Clause side, I know sort of legal realist in me tells me that, with the exception of Lopez and Morrison, every single emanation of congressional authority to regulate myriads of things, intra and interstate, things that have significant impact and insignificant impact, especially cumulatively in the context of broad regulatory scheme, is kosher. Now, why do I think this is different? Well, Lopez and Morrison is still good law, 1995, 2000. But it's not even the details of the cases that matter. You cannot read those two cases, especially without reading, if you read Justice Kennedy's concurrent appearance in Lopez.